We're on the record.
The appellate court for the state of Connecticut is back in session. We will now hear the matter of Osborne versus Commissioner of Correction, docket number AC 43019. I am Judge Mall. I have the pleasure of sitting this afternoon with Judge Cradle and Judge Pellegrino. Because we are still in the midst of a pandemic, we are conducting this hearing virtually using the Microsoft Teams platform. Before I have everyone state their appearances for the record, let me alert or otherwise remind everyone that this argument is being live streamed on the branch's YouTube channel. Accordingly, to the extent this case involves any protected identifying information that should not be disclosed, counsel are reminded to be careful not to disclose such information during arguments. I would now ask that everyone participating in the hearing please identify themselves for the record, starting with the judges, then counsel for the appellant, then counsel for the appellee. Again, I am Judge Mall.
I'm Judge Cradle.
I'm Judge Pellegrino.
And counsel.
Good afternoon, Your Honors. Peter Billings for the petitioner appellant in this matter, Antoine Osborne.
Nancy Chupak for the Commissioner of Correction.
All right, counsel, prior to this argument, you should have received procedural instructions. I know you both have participated virtually before, but do you have any questions before we begin?
No, Your Honor.
No, Your Honor.
Okay, and a few additional preliminaries. When you are not speaking, if you would try to remember to turn off your mic while leaving your video on. We want to ensure that we don't lose anyone during the proceeding. And also, I know this is not necessary with the two of you, but let me state the obvious. Try to comport yourself as though we were in the physical courtroom, avoiding doing anything that might be distracting for the judges or opposing counsel. Each side will be permitted 20 minutes of argument. I will endeavor to give you a 2-minute and 1-minute warning. The appellant may reserve a portion of the 20 minutes for rebuttal. Attorney Billings, are you ready to proceed?
Yes, Your Honor, I am.
All right, you may do so. And how much time do you wish to reserve, if any?
All right, this time I would like to reserve 5 minutes for rebuttal.
All right, that's fine. Go ahead.
Good afternoon again, Your Honors. Peter Billings for the petitioner appellant, Antoine Osborne. So this case raises an interesting scenario that I think comes up quite a bit in the trial courts. And the situation is fairly straightforward. Essentially, there's a criminal trial. One of the key witnesses has pending cases while the petitioner's underlying criminal case is progressing. And the witness is arrested or taken into custody. He's handcuffed to a hospital bed. He's arrested, I believe, charged with 3 cases, some of which being felony charges. And as that case plays out, they are ultimately nollied. At the time of the criminal trial of my client's case, the prosecutor handling it is not handling the...
Counsel, I have a question.
Yes, Your Honor.
What date were they nollied? I couldn't find that in the record.
I don't know. I can certainly take a moment while the state is arguing. I can try to look through the appendix and get that exact date. I don't have it before me. It's my understanding based on the record that it was prior to the criminal trial of the petitioner.
Yeah, but don't you think it's critical as to how long before the trial those charges were nollied?
I don't think it's necessarily critical. I could see a scenario where obviously the closer to the trial, the more weight it may give. However, I could also see a scenario where it's nollied at the very start of the case as a part of, hey, Mr. Witness, will you talk to us? We'll nollie the case if you talk to us about this case. So I can envision scenarios in both directions, either at the very beginning of a case or very close to the trial. So I don't necessarily think the date is essential to a resolution of this situation. So
I think it is essential, and if you could provide me with the date, I'd appreciate it.
Yes, absolutely, Your Honor. During my time when the state is arguing, I will certainly endeavor to provide that information and get you a specific date.
Thank you.
In this situation, I think what strikes me and what I see every day what I used to see every day in the trial courts is one prosecutor in one court not necessarily knowing what's going on in the other. And here the commissioner's argument is essentially we haven't met our burden because we don't know what these other prosecutors were doing. And it would seem to me that the state, and I believe that the case law is supports this, that the state has the obligation to determine and see what is going on in the other cases. And here that didn't happen. So this is a situation where there's an essential witness who has multiple arrests. The cases are just outright nollied. There's no explanation for why. Clearly, there's a significant benefit conveyed to that witness, and that witness provides damning evidence and testimony against our client. Trial counsel was not able to cross-examine sufficiently on this. They didn't have an official agreement. Trial counsel for the state indicated that he was unaware of whether there was an agreement or not, but he should have gone out and determined if there was an agreement. And had there been a specific agreement, I think it's very clear that he would have had to disclose that information. So that's the first issue. If there are no questions on that, I will move on to the second issue that involves the expert in a firearm. Yes, Your Honor.
Attorney Billings, with respect to the victim, and in your view, there must have been, some kind of cooperation agreement. Was there testimony at any time by that individual that at the time he testified in the underlying trial that he was not in compliance with the registration requirements?
I'm sorry, I don't think I'm understanding your question.
Well, I mean, part of your theory is that at the time the victim testified at the underlying criminal trial, he was facing a failure to register charge, correct? Or which had been nollied.
Yes.
So my question is, was there testimony at any given time that when he testified at the underlying criminal trial, he was still out of compliance with the registration requirements?
I believe there was testimony about the specific charges and that he was out of compliance. I believe that was subject to and elicited during cross-examination. There was not testimony that at any point, I believe at the trial or throughout the habeas proceedings, that there was an explicit deal between the state and the witness.
All right, thank you.
Counsel, what kind of a deal could there have been if the charges were nollied? He didn't have to, if the charges were nollied, what kind of a deal could there have been?
Yes, Your Honor. So in my view, in the petitioner's view, this could be a situation where the police or the prosecutors say, Mr. Witness, if you give us a statement, if you provide this information, we will nolly these pending cases and we'd expect you to testify. If you don't, we can reopen these nollies. They would have 13 months to do that.
That's why I think the date is important.
Yes, Your Honor.
When they were nollied.
Yes, Your Honor. Again, I will work to get that date. So I believe that there are any number of deals that could have been worked out between the prosecutor, even though the case was nollied.
Wasn't there testimony, though, also elicited from the state's attorney's office that they weren't planning on calling him as a witness?
I believe there may have been that testimony. However, he did ultimately testify.
Well, but isn't it true also, though, that he wasn't cooperative through the entire process with the defense or with the state?
Yes, but then I think that fact weighs in favor of the petitioner's position. Once he is arrested, and I believe there's testimony from, I believe it was Attorney Bocchicchio, who indicated that for some unknown reason, this defendant turns himself in, knowingly cooperates, he goes to the hospital, he's handcuffed, and then he he's ultimately the cases are nollied. So initially he was not cooperative, but then at some point he became cooperative. And I think that goes to a scenario where the police or someone could have very easily worked out some sort of agreement, say, hey, look, we need you for this case. If you come in, we'll work out some favorable disposition. And it may not have been as clear as.
Was there any testimony elicited from anyone that suggested that he was going to procure any sort of benefit by testifying?
There was no testimony to that effect. The testimony from Attorney Buquicchio was he was not aware of any such deal. I think that stands in stark contrast to a scenario where a state's attorney could have gone to his office and undertaken to get this information and said, I put out a notice to the office, I sent out an email to the attorney who handled the case, I took an affirmative step to confirm that no, there was no deal ever discussed or ever contemplated or ever suggested. Here, he just simply, the testimony is simply that he was not aware of any deal that was offered to the witness. But it's the petitioner's argument that he should have and is required to take an affirmative step to confirm that information. He's an agent of the state, and he's held to the obligation of the state as a whole, not just himself individually. So, if there aren't any further questions on that particular issue, I'll be very brief on the second issue. I think the second issue is fairly straightforward in that the trial counsel acknowledged that she did not at any time consult with, discuss, or seek the opinion of a firearms expert. I think in this case, the testimony of the witnesses of the alleged shooting was very important to the state's case, and the fact that there was no testimony and no evidence of anyone seeing a muzzle flash with from my client's area, I think that is extremely helpful to the defense. So if in fact the majority of the testimony wasn't that they saw the shooting, but that they saw him with a firearm, and the fact that no witness ever saw a muzzle flash in the petitioner's area would be exculpatory and a very important piece of a factual defense. And I think had she hired counsel, had counsel hired an expert, that type of testimony would have been very helpful and persuasive to a jury. So the fact that not even an opinion was sought, there was no investigation, and again, counsel acknowledged during her testimony that there was no strategy reason for doing this. She recognized that there was in fact that this evidence could be helpful, in fact likely would have been helpful in front of a jury. So I do believe that here there is significant error in behalf of trial counsel, and it did prejudice the petitioner in his underlying case. If there are no further questions in regard to that second issue, I will rely on my brief for the rest of this argument.
All right, I see no other questions from my colleagues, so you'll have the remainder of your time for rebuttal.
Thank
so
you.
If you would kindly just mute yourself, Attorney Billings. Attorney Chupak, you may proceed.
Thank you, Your Honor. And just to begin, to answer the question, Heeman's cases were nollied December of 2011 and February of 2012, and that was over a year before the petitioner's trial began in April of 2013. And that those were findings made by the habeas court, and they are in the state's brief on page 11 in the block quote pertaining to Brady Giglio findings by the habeas court. The habeas court properly denied the petitioner's claim that the state suppressed material, impeachment evidence in violation of Brady and Giglio because the petitioner failed to show that there was a cooperation agreement between the state and Heeman's. The prerequisite for any Brady Giglio claim is the existence of an undisclosed agreement or understanding between the cooperating witness and the state. And a petitioner carries the burden of proving such an agreement exists once he raises a Brady-Giglio claim. In this case, the petitioner failed to show that the state entered into such an agreement with Hemans. Attorney Bochicchio denied entering into any such agreement or authorizing any such agreement with Hemans, and he testified that he would have been the only prosecutor with the authorization to do so. The petitioner did not call Hemans to testify at his habeas trial, or the prosecutors in the Enfield and Hartford Part B courts who handled Hemans' cases. He also did not proffer any court documents from those cases reflecting a cooperation agreement. Instead, he relies on the fact that Hemans' nollies were entered while his case was still pending, and that one of Hemans' cases was in the Hartford Judicial District, the same jurisdiction as his own case. However, these two facts, combined separately or combined, do not give rise to the existence of a cooperation agreement or even imply that one exists. First, because Hemans' cases were nollied in December of 2011 and February of 2012, over a year before petitioner's trial began in April of 2013. And at the time that Hemans' cases were nollied, the state's plea offer was still pending, and according to Attorney Baer, the defense was seriously considering the plea offer. So there was, at that time that the Hemans' cases were nollied, it wasn't even clear that the petitioner would be going to trial, let alone that Hemans would be testifying. The fact that Hemans' cases were nollied over a year before also undercuts the existence of a cooperation agreement, because it makes no sense that the state would agree to nolly Hemans' cases in advance of his testimony, because then he would have no incentive to testify. Consequently, the timing of the nollies doesn't show or imply the existence of an agreement. The fact that one of Hemans' nolly cases was in the same jurisdiction as the petitioner's also is insufficient by itself or combined with the timing, because petitioner hasn't even showed that the Hartford prosecutor who nollied Hemans' case knew about the petitioner's case, let alone offered Hemans or had reason to offer Hemans an agreement. The petitioner's argument in his reply brief that it was only after Hemans' cases were nollied that Hemans suddenly called Attorney Bochicchio and expressed a desire to testify fails, because it makes it sound as if Hemans showed up to testify directly after his cases were nollied, which is not true. His cases were nollied over a year before the petitioner's trial began. As a result, the two events were not close enough together so that such a connection could be inferred between the nollies and Hemans' willingness to testify. Similarly meritless is the petitioner's argument that it is the state's obligation and not his to determine whether any promises were made to the witness by any prosecuting attorney. Brady-Giglio does not require a prosecutor to go out and find material exculpatory evidence that he has no reason to believe exists. Those cases only require him to produce evidence that he knows about and not to turn a blind eye to any Brady material. Even assuming that a trial prosecutor has an obligation to investigate if any promises were made to Hemans in return for his testimony by other prosecutors, the petitioner still carries the burden of proving the Brady-Giglio violation he alleged occurred, and he did not do so. Additionally, for the reasons noted on page 17 of the commissioner's brief, even if the petitioner somehow demonstrated the existence of a cooperation agreement and that Hemans was aware of it and that he testified falsely that there was no such agreement, the petitioner failed to show that the agreement constituted material evidence, because the state was not wasn't even sure it was going to call Hemans, but it certainly wasn't relying on Hemans when it had two eyewitnesses who knew the petitioner and identified him as the shooter. With regard to the second issue, the habeas court properly rejected the petitioner's claim that Attorney Baer rendered ineffective assistance when she did not consult with or call a firearms expert to testify at trial. Because the petitioner failed to show that an expert was available, and would have benefited the defense. It is well established in our law that if a petitioner raises a claim that his counsel was ineffective for not consulting with or proffering the testimony of an expert, he bears the burden of showing that an expert was available at the time of trial and that the expert's testimony would have benefited the defense. The petitioner failed to make either showing here. He did not call a firearms expert to testify at his habeas trial or proffer any evidence that showed that an expert was available and would have testified favorably to the defense that muzzle flashes would have emanated from the type of gun used in this case. Therefore, he failed to show that Bear performed efficiently and he was prejudiced. Additionally, as the habeas court noted, the petitioner failed to show that any favorable expert testimony, if it existed regarding muzzle flashes, would have undermined Spike's testimony because Spike did not testify either way, whether to seeing or not seeing muzzle flashes at the petitioner's criminal trial. In his reply brief, the petitioner changes his argument and contends that Bear should have called or consulted with a firearms expert, even if it was clear that the gun used by the shooter would not have produced a muzzle flash, because a firearms expert would have assisted her in crafting her cross-examination of the state's expert and Howard. His new argument should not be reviewed because it wasn't raised below, either at trial or in post-trial brief. But even if it is reviewed, the petitioner still hasn't shown that a firearms expert was available to him, and even if an expert was, what specific value the expert would have provided with regard to cross-examination. In addition, it is unclear to the commissioner which or what expert the petitioner is claiming an expert on, what state's expert the petitioner is claiming a firearms expert would have helped Bear question or cross-examine. It looks like the only person who testified about the specifics of firearms was the crime scene investigator, Detective Sergeant Jeremy Ball, and he didn't testify as an expert. He only testified that he found 3 shell casings, and these shell casings were stamped with the manufacturer, Winchester, and the type of shell casing, a 38 automatic. So it's unclear how cross-examination would have been enhanced if an expert was even available. For all these reasons, unless the court has questions, the commissioner requested the court affirm the denial of the petitioner's revised amended petition.
All right, seeing no questions, counsel, thank you. Attorney Billings, you'll have 9 minutes for a rebuttal, but you are on mute.
Thank you, Your Honor. At this time, I have nothing further. If there are any questions, I would gladly answer those.
All right, seeing none. All right, counsel, thank you again for participating in this virtual format. Hopefully we'll be back in the physical courtroom sooner rather than later. The court will take the matter under advisement and the court stands in recess until 3 p.m.
Thank you.
How do we get out of here?